There we go.
Good afternoon. Thank you all for joining us virtually today. We had a few technical things to get together there. I apologize for starting a little bit late. The discussion today will be regarding a complaint that my office filed this morning in Franklin County Common Pleas Court against First Energy, former House Speaker Larry Householder, and various and sundry 501c4s and related organizations, as well as some of the people that have been indicted by the United States Department of Justice related to House Bill 6. A little bit of background first. The Ohio Revised Code provides for something commonly called Little RICO, or the Ohio RICO statute. It's formerly the Engaging in a Pattern of Corrupt Activity statute in 2923.32. That is a criminal statute, and that is not what we're doing. As many of you covering this event know, the Attorney General has no independent prosecuting authority in Ohio. Prosecuting authority rests with local jurisdictions, locally elected prosecutors. So I'm bringing this on behalf of the state of Ohio as a civil action under a related statute, which is the civil engaging in a pattern of corrupt activity statute in 2923.34. It's an overlay of the criminal statute, and it basically says if you can show if you can show an offense under the criminal statute and prove it just by preponderance of the evidence, then you can win damages and injunctive relief of various sorts. And the statute goes on to describe exactly what the court is empowered to do. It's a pretty broad statute. So the elements remain the same, and what changes is the nature or the standard of proof. In the criminal case, obviously, it has to be proven by proof beyond a reasonable doubt. And in a civil case, it's by preponderance of the evidence, which is a lower standard. Some of you may remember an Ohio case some years ago involving the death of Gene Schrader. There was no criminal prosecution. There was an attempt, though, to bring a civil action. Obviously, that wasn't a corrupt enterprise, but that illustrates the difference between the standards of proof. So, under the engaging in pattern of corrupt activities, there is simplifying a couple of things you have to prove. The first is there's got to be an enterprise. It can be people, it can be companies, organizations, corporations, various kinds of entities, and they have to act together for a corrupt purpose, which is defined in the statute. And they have to have two or more what we call predicate offenses. And those are criminal offenses, and they're listed out. So not every criminal offense is a predicate offense. In our complaint, the predicate offenses are money laundering, extortion, bribery, and tampering with evidence. To hit just a couple of high points, I want to talk briefly about the harm that came to Ohio from this. And I want to make sure that I point out that the United States Attorney is holding the actors in this episode criminally accountable in the federal courts. This is a civil action. Nobody's going to go to jail because of this lawsuit. If a jury agrees with the federal government in the federal case, people could go to jail. And that's an important distinction. But there's also things that the federal complaints, criminal complaints, cannot reach. And the civil complaint filed today by the state of Ohio can reach. The first and most important thing is the $1.3 billion that will be taken from Ohio electricity ratepayers under House Bill 6, a substantial sum of which, the majority of which, is going to go to support the non-profitable nuclear energy reactors formerly owned by a subsidiary of First Energy and now operating post-bankruptcy under the name of Energy Harbor. We are seeking a court order to prevent that money from being distributed to Energy Harbor because it is essentially ill-gotten gains. The corrupt activity should not result in a monetary advantage for the people who acted corruptly. Ohio's ability to harm it, or govern itself, has been harmed. Distrust between officials, elected and appointed, is high. Ohio's citizens' trust in their government to act in an ethical and honest manner has been eroded. Ohio's reputation among the states has been damaged as a place that you can come and do business, that has a fair and clean government. And Ohio's environmental future has been damaged. Through the associated bankruptcy case that First Energy Solutions, now Energy Harbor, went through, a number of cleanup obligations, some obligations to the state of Ohio were compromised, and obviously in the future, the decommissioning costs associated with these plants when they're shut down is now covered by a company that has far less capitalization than First Energy did. Those costs, as well as the matters that were dissolved, if you will, in the bankruptcy proceeding, are now, the last stop will be Ohio taxpayers. So what are we asking for? The relief we're asking for is first, obviously, an adjudication that the acts that we're complaining of in this lawsuit be declared, in fact, corrupt and a violation of the statute. We're also asking, as a technical matter, that $1.3 million, we're asking the court to invalidate any authorization by the Ohio Air Quality Development Authority, which is simply the technical mechanism for the flow of that money. We're asking that to be restrained pending the outcome of this litigation. The third thing we're asking for is that the defendants in this lawsuit be restrained from receiving any monetary benefit, and that can include a supplement, a credit, an offset created through House Bill 6. We're further asking for defendant organizations and businesses to be dissolved or reorganized so that any of the persons that were involved in the corrupt activity may no longer participate in the affairs of that business or organization. We're asking that any defendant be prohibited from holding any position or office with a government entity, a campaign committee, a candidate committee, political party organization, political action committee, regulatory board, government agency, or any entity formed pursuant to the IRS Code Section 501c4. And we are asking that the defendants be enjoined from any and all lobbying activities for a period of 8 years. In addition to those requests for relief, we're also asking for a couple of preliminary injunctions to go into effect immediately. The first is that the defendants be prohibited from any lobbying whatsoever regarding the repeal or replacement of House Bill 6. Secondly, that the defendants be restrained from supporting or opposing candidates for election this fall in the General Assembly elections. And finally, we're asking that the court freeze the assets of Friends for Householder, the householder campaign account, and that any expenditures from that campaign account in excess of $250 would have to be approved by the court. That's the essence of the lawsuit. We now will enter litigation and discovery. I'd like to add one additional point about this, and that goes to the question of the General Assembly's debate over the repeal and replacement, potentially, of House Bill 6. House Bill 6 does a lot more than bail out the nukes. It has a lot of technical components, and many people in the marketplace have made decisions over the last year based on that legislation. There are implications in the marketplace. People have made buying and selling decisions, business decisions, as well as lending decisions. All of those things are inextricably intertwined with what happens with House Bill 6. Now, without expressing any desire for what a replacement would look like, I don't have a vote in the General Assembly, and I don't think they need my opinion. Certainly haven't been asked for it. The fact of the matter is, this is going to require some serious skull sweat to unwind it in an appropriate and fair manner that doesn't create more victims, more disruption, more chaos. So I commend the leadership in both the House and the Senate in conducting hearings and considering this matter carefully so that they don't come up with an easy political solution, but instead a good policy solution for Ohio. And the filing of this complaint today should not be construed in any way of a suggestion or an analysis on my part that they are moving too slowly. To the contrary, I think they are doing what they ought to do, which is carefully consider and deliberate. What is happening is, while everything else continues to go on here, we feel that there are needs to restrain some of these activities. So we filed this lawsuit today, begin discovery, bring additional facts to the table, and to prevent the money that is out there from benefiting the people who acted inappropriately. So with that, I'll be glad to try to take any questions. I will warn you that this is pending litigation, so there are some things that will come out through discovery that aren't known yet, as well as some things that I'm going to decline to discuss at this point, having just filed a lawsuit.
Okay, Attorney General, your first question is from Noah Blundo at Hannah News.
Hello, can you hear me?
I can. Noah, how are you?
I'm good. How are you?
Tolerably well.
Thank you. So how intertwined is this with the federal lawsuit in terms of the need for things to be proven there in order for you to carry forward? And also just in terms of the schedule, you're asking for short-term injunctive relief, but for you to actually prosecute this case while the feds are prosecuting theirs, do you have to wait on them, or how does this operate as you see it?
So I've been in, fair question. I have been in contact with the prosecutor, the United States Attorney for the Southern District of Ohio, Dave DeVillers. He's aware, and we gave him an opportunity to look at this lawsuit before we filed it. The only concern that he had is that we coordinate so that we aren't getting in his way on particular pieces. But there's a lot here in my lawsuit that does not overlap with his criminal prosecution. And there are some things in his criminal prosecution that are not especially relevant to the lawsuit that I'm bringing. So I will be communicating with him in an appropriate manner at appropriate times to make sure that neither of us are compromising the other's work. And if it comes down to it where somebody's got to go first, the criminal complaint will need to progress more quickly than the civil complaint.
Thank you.
Okay, your next question is from Adrian Robbins with Channel 4.
Thank you for doing this today. Progress Ohio and some other organizations are calling for an independent special prosecutor due to your ties to some of the defendants, including Matt Borges. Do you think you can fairly represent the people of Ohio on the issue of House Bill 6?
Absolutely. And I want to point out that while it is appropriate to talk about prosecuting a civil complaint, a prosecutor is a term that we use in the criminal realm. So talking about a special prosecutor is inappropriate here because I'm not bringing criminal charges. I assume that Progress Ohio must mean outside counsel. However, this is a job I was elected to, and I've proven my independence over the last 10 years in state office. I call balls and strikes, and hey, look, I sued these folks.
Okay, your next question is from Kevin Landers at Channel 10 TV.
Hi, Kevin.
Dave. Hey, Dave. So it's my understanding that the fees that would go into effect would start in January of 2021. So if this lawsuit isn't heard before then, does that mean that First Energy's subsidiary will be able to continue to charge ratepayers, or will this lawsuit today actually put a stop on any kind of collection going forward? Thanks.
Thank you. So our intention is to prevent money from flowing to Energy Harbor through this lawsuit. Now, the question gets a little technical. For a preliminary injunction, we have to show a threat of imminent harm. And because that fee does not go on until January and wouldn't in any case begin to flow probably until April of 2021, it's a little hard for me to go into the judge and say, Judge, I need an order, I need an injunction right now because I've got imminent harm. We've actually got several months yet. And the legislature is continuing to do its work, its hearing, its deliberations. And these issues may be resolved by a replacement bill. There's a lot of unknowns about that, but we are asking for an injunction and will, if necessary, move for a preliminary injunction when the time comes closer. And we're confident that we've got good grounds to for the court to grant it.
Your next question is from Jeremy Pilzer at cleveland.com.
Hi, Jeremy.
Hi, General. Hey, I wanted to see if your lawsuit would affect, I wanted to confirm your lawsuit would not affect any other parts of HB6, especially regarding OVAC or the solar plants or even decoupling for First Energy. Thank you.
Thank you. So I'm going to try to answer that. You were breaking up a little bit, so if my answer isn't complete enough for you, we'll give you a shot to ask a follow-up question, because I'm not sure I heard everything. But as I understood it, you were asking, is this focused on the nukes or the other provisions of House Bill 6 implicated in our lawsuit. And the answer to that is we are at this point focusing on the nukes because that is the tie-in to the corruption. There are a lot of other elements, as I previously mentioned, to House Bill 6 that affect lots of different people and players in the energy system. And as of today, we can't really tie the corrupt activity into those pieces. So it's certainly possible that new evidence could arise in the course of discovery, but I don't know that it will. I'm not predicting that it's even likely. All I can say is that as the record exists today in 2020, the lawsuit does not reach any farther than the nuclear questions.
Your next question is from John Bedell with WHIO.
Attorney General Yost, thanks for taking some time for us today. Two questions. One, do you support replacement of House Bill 6? And secondly, what more action is needed by the state to prevent a repeat of this kind of dark money influence?
That's two questions. Is he allowed to ask two questions?
We'll give over.
As I said earlier, I don't really think that the legislature cares very much what the Attorney General thinks. I don't have a vote on legislation and I don't have a veto. For the record, as an office holder and someone who the citizens might want to know what I think, I would like to see House Bill 6 repealed. I think there are enough other things involved with Ohio's energy policy that are impacted by House Bill 6 that a replacement bill is warranted. What that looks like, I leave to the sound discretion of the legislature. And the second part of your question was what needs to be done to prevent this from happening again? And the answer to that is a lot. There are several things that come immediately to mind. I would love to see a law that prevents one 501c4 from giving money to another 501c4. That at least would eliminate the shell game that we saw here. That's an easy and a small thing that is not going to be enough in itself, but is worth doing. There are other things about transparency that we ought to be having a discussion about, but maybe the most important thing is this lawsuit itself. You see, as much as I want to get the injunctive relief, think about the other things that we're asking for in the injunctive relief. The ban against lobbying, for example, the elimination of the bad actors from participating in the system for the next 8 years. These are novel remedies that haven't been sought before. We think they're within the sweep of the statute and hope that the court will give them to us. But why are we doing that? Because corruption doesn't happen on an industrial scale like this without cash, lots of cash. And it's incredibly important at this moment in our state's history to send a message that the Ohio political system, the Ohio lawmaking system, that the regulatory environment is not for sale. And you shut off the money spigot and the corruption withers. The incentive goes away. Make no mistake about it, Larry Householder doesn't get to do the things he did without the money that was provided for him to gain power. So this lawsuit will send a message that if you're going to play clean.
And your next question is from Jesse Beaumont with Cincinnati Enquirer.
Hey, Jess.
Hello there. I have some questions about the relief that you're seeking. Obviously, 8 years of not being able to lobby and not being able to participate in campaigns could be pretty devastating for some of these people. Would that apply to other groups like Hardworking Ohioans or Partners for Progress, some of the people not specifically named? And then kind of a side question is, would this affect Representative Householder's ability to campaign for his seat this fall?
Okay, so the first question is, we're looking for that relief on named party defendants. And there's a list of them on the front page. It's possible that there may be additional defendants as we go through discovery. With regards to, will this impact Speaker Householder's ability to campaign? I assume by this you don't mean the lobbying ban that we're seeking, but rather the restriction on friends of householder. Yes?
Yes, correct.
Okay. I'm sure it will make it a little more difficult for him to campaign, but we try to recognize that there are competing First Amendment issues here. He's not prohibited from spending that money, but he has to go to court and explain what he's going to do if it's more than $250 and get permission if that order is granted. Of course, it has not been granted as we're talking right now. The purpose for that is very specific. What we see throughout the history of the speaker's career is that he spends a large amount of money, not on himself, not on ads saying elect Larry Householder, but supporting the candidacies of people who will be loyal to him, who will perhaps listen more favorably to him. And we think that's an inappropriate use of that money. There was over $1 million at the last report in his campaign account, vastly more than you would legitimately need to defend a seat in Perry County, Ohio. And so we want court oversight of that to make sure that he's not buying favor or protecting House Bill 6 by expenditures from that campaign fund, which was significantly funded from the corrupt First Energy money.
Okay, your next question is from Farnoosh at the Associated Press.
Hi, Attorney General Yost. Thanks so much for taking the time. My question is, how much did the deadline of October 1st to get this done legislatively impact your decision to file this lawsuit today? As obviously millions of Ohioans would have had to get that additional charge on their bill come January, and now they know and believe that this law was passed corruptly and not in their benefit.
Well, once the legislature set up their deliberative process in the Senate, they're having multiple hearings. In the House, they've established a select committee to have hearings. It became evident that there would not be a quick resolution to the repeal and replace question. And at that point, we were already developing this lawsuit. There was a lot of legal research and a lot of fact finding that went into putting this together. So the timing is mostly we got finished with it and we're ready to go.
Okay, your next question is from Sean Hegarty at ABC 13.
Good afternoon, sir. What and how much concern do you have for the people in Fulton, Lucas, and Wood counties who count on Davis-Besse that this could stop the operations at Davis-Besse or could cause some permanent closures there at the plant?
Well, I'm deeply concerned about that. Ohio needs those jobs, well-paying jobs. And as one citizen's opinion, I frankly think that energy diversity is a worthwhile goal. I certainly hope that those plants don't close down. But that is a question for debate in the legislature. My role as the chief law officer of Ohio is to restrain the enjoyment of these ill-gotten gains that are the fruit of corruption.
Next question is from Andy Chow with Ohio Public Radio.
Hi, Attorney General.
Hi, Andy.
I wanted to get back to, I think it was Kevin's question a while ago, when it comes to the charges that ratepayers will begin to see because of HB 6 beginning on January 1st. So are you saying that this lawsuit could be a vehicle that could be used to stop those charges from beginning to appear on ratepayers' electric bills in January?
No, what we're asking for is the restraint against dispersing that money to any of these defendants that are named in the lawsuit. It's important to recognize that revenue stream actually goes to multiple places. And some of the places don't have any tie-in to the corrupt activity that we're complaining of in the lawsuit. So the legislature could and should act to rectify this situation and replace the existing bill. And at that point, the rate can be adjusted if necessary, eliminated if that's the choice of the legislature. But our main goal in it was to preserve the status quo for the policymakers to make their decisions.
Okay, next question is from Jim Providence with the Toledo Blade.
Hi, General.
Hi, Jim.
Hi. Could you walk us through the $1.3 billion figure that you provided? I'm assuming that includes the bailout money. Is that also including the decoupling money? And when it comes to the freezing of the assets of the players in this scheme, does that include the personal assets of these individuals? Attorney General, if you can hear me, it sounds as though you are muted.
I swear I didn't touch it, Jim.
Thank you.
So what we're trying to attach there is what's listed. These are the accounts that are going to be associated with the C4s, with Longstreth Associates. It does not reach any and all assets that they have previously owned. And I don't know that we have the legal grounds to ask for that. Let me rephrase that. We don't have legal grounds to ask for that. The $1.3 billion is an estimate, and the amount is almost certainly different than that. Without diving too deeply into House Bill 6, that is subject to PUCO review and an audit to assess need for those. So the 1.3 billion is an estimate that will be proven up by evidence as we do discovery.
Next question is from Marty Schladen with Ohio Capital Journal.
Good afternoon, General Yost. How are you?
I am well, sir. And you?
I'm doing okay.
Good.
You talked about corrupt First Energy money and the shell game of money passing between 501c4s. Does that include First Energy money that flowed through Partners for Progress and into Generation Now? And also, do you think the PUC should mount an independent investigation into whether ratepayer money was a part of this money that went through this scheme?
Thank you. So I'm sorry, I was thinking about the PUCO, and refresh me again what the first part was.
In terms of, corrupt First Energy money and the shell game.
Okay. Yeah, it did include that. It does include that. With regards to the Consumers Council's request for an independent investigation by the PUCO to whether ratepayer money was used, that's a decision for the PUCO. and I don't have an opinion on it. I would not oppose that if they chose to do so. They choose not to do so. That could well end up being part of the discovery that is undertaken in this lawsuit. I do think that whatever the mechanism is, I think that that's a question that ought to be answered.
Thank you.
So next question is from Tom Bosco with Channel 6.
Tom.
Hi, Attorney General Yost. So what I'm hearing is that it sounds like you are pessimistic that the lawmakers can get something passed by October 1st. If and when they pass something, would you withdraw this lawsuit?
Depends what they pass and whether it addresses the problems that we've raised. We'll have to assess that when they pass something. But it's certainly possible that the General Assembly could take an action that moots this lawsuit.
Next question is from Brian Eckhaus with Bloomberg News.
Hi, how are you?
Actually, I want to go back to Tom's question for a second because I didn't answer that quite correctly. There are certain pieces of this, for example, the injunctive relief regarding the actors within the private sector entities and the political actors that would not be affected by the General Assembly. So at least that piece of the complaint would survive potentially the passing of a replacement bill. Thanks for letting me supplement that answer, Tom. All right, next.
Hi, you say in the filing, you said this earlier as well, that each defendant business entity and nonprofit entity named in this complaint be dissolved or reorganized. What does that mean exactly? Does that mean you're looking to dissolve First Energy and Energy Harbor, or something more nuanced than that?
Well, the dissolution would apply to the 501c4s that were merely shell corporations used to launder money. They were laundromats. The reorganization would be to whoever was responsible at First Energy. We think that the court should remove them from their position. That they shouldn't be, because of this wrongdoing, shouldn't be in a position to continue.
So it's not a corporate reorganization. It's looking simply to pull people out that you believe, or you'll find to believe, are culpable in this case.
Well, it could go farther than that. There might be a reorganization that the court would find appropriate. We're not trying to dissolve First Energy.
Got it.
So the last question is from Mike at NBC24, and he would like to know, what does this mean for regular Ohioans? Why should they care?
Well, regular Ohioans should care about this for a couple of reasons. Number one is their energy bill. The electricity cost is affected by House Bill 6. And there's a lot of ways, a lot of arguments about how it does that and what pieces might or might not last. But at the end of the day, there's nothing that comes, more to the kitchen table than paying your electric bill every month. And there was going to be an increase in costs because of a corrupt piece of legislation. More importantly, though, and while this might not fit at the kitchen table quite as well, Ohioans should care about this because we need to be able to count on our lawmaking process to not have this kind of corruption involved with it. Regular Ohioans should be glad to know that people are going to be held accountable, not just the public officials going to jail if that's where the criminal case comes out, but the people that fund this, the people that fill the money hose are kept out of the process and that they're held accountable, and that a message is sent to everybody that wants to try to get private gain out of the public good, that they're being watched, and there's consequences to acting like that.
Attorney General, this is Andy Chow. Do you mind a follow-up?
Sure.
So you just said that people should care because they should care about the extra charges on their electric bills. But you're saying that those extra charges that were created through HB6 will still appear on people's electric bills starting January 2021, with or without this lawsuit.
Well, that's not quite what I said.
Okay, please, yeah, because that's where I'm confused.
Okay, so at the end of the day, there could be. So I guess the best way to do this is to war game it. The legislature between now and December 31st could do a replacement bill, repeal and replace House Bill 6, and we would have new rules. Those new rules could possibly eliminate that surcharge. They could cut it. They could redirect some or all of it. And that's up to the legislature. If they don't, the next legislature will perhaps take this up. And at that point, what's happening is this money is still susceptible to be refunded. While it's collected, while the bill is still in place, it's not going to go to the nukes if our injunction is granted. Where does the money go? It stays in the Treasury until the General Assembly acts or the lawsuit's resolved, and then it would go out according to whatever the law is at that moment. But one of the things that can and will happen if the money is continued to collect is that the General Assembly is going to direct what happens to that money. And one way or the other, this is going to have an impact. So I hope that you can ask another follow-up if that wasn't clear.
It does. Thank you very much. I appreciate it.
Thank you. And thank you all for joining us. I have another commitment I've got to get on the road for, but Bethany McCorkle is available to you if you have any follow-up questions. We want to do our best to answer your questions or get you the information to the best of our ability. Thank you.